have 15 minutes to present your arguments, and the appellant may reserve up to 5.
Thank you.
Thank you.
Good morning.
Good morning.
Ashley Loihe, counsel for the plaintiff appellant Dan Keehan. I'd like to reserve 3 minutes for rebuttal. Today we ask this court to reverse the trial court's dismissal of the plaintiff's case pursuant to 12b6 of the civil rules for failure to state a claim. Plaintiff put forward 2 claims for relief, one in common law, a Greeley claim for wrongful termination, and one under the revised code 411352 for the whistleblower statutes. So in order to sustain a trial court's 12b6 motion, an appellate court must find that the plaintiff can prove no set of facts that was entitled him to relief. Obviously, a no displeading claim here. And as long as there's a set of facts that's consistent with the complaint, which would allow the plaintiff to recover, a court may not grant a defendant's motion to dismiss. And it is the plaintiff's opinion and position that we have adequately claimed pursuant to no displeading both the wrongful termination claim under common law and the whistleblower statute pursuant to 411352. The elements for common law wrongful termination are clarity, jeopardy, causation, and no overriding justification. With respect to clarity, there must be a clear public policy existed and manifested in law. The statute itself does not have to prohibit termination, rather, and discharge does not have to violate the statute. There just must be a public policy in Ohio law that is manifested in that statute. The jeopardy element is dismissing the plaintiff under the circumstances would do harm to that public policy in that Ohio law. The causation, the dismissal, must be motivated by the plaintiff's conduct regarding the public policy, and no justification, obviously, if it's a bad employee, can't hide behind that common law wrongful termination. With respect to the complaint, the plaintiff alleged 4 different Ohio laws which would find the roots for that public policy that would meet the clarity element, revised code 5739 with respect to sales tax, Title 57 with respect to the W-2 accuracy, 8 U.S.C. 1324A with respect to hiring eligible employees, and then 2307 with respect to non-conforming airline parts entering the stream of commerce. The plaintiff further alleged that the jeopardy element was met as well, and that's twice in the complaint that the plaintiff stated that the dismissal of the employee was contrary and would have put in jeopardy those 4 statutory public policies. Causation also was alleged in the complaint, and the justification outside of that dismissal was also alleged in the complaint. The trial court dismissed on a number of grounds which we allege are in error. First, the trial court alleged that the complaint did not state the clarity element well enough. The trial court argued that because the complaint never said why or how public policy was jeopardized, that just merely citing to the statute wasn't sufficient for the pleading. However, that's contrary to case law. The case in Rebello and from the 8th District states that the clarity element is met simply by citing to a statute. And in this case, we cited to 4 different statutes outside of the whistleblower statute. Furthermore, the federal court did, in its order from which this case was remanded, found that there was a colorable claim from 2307 for the non-conforming airline parts. It's directly in the federal court order, so it's curious that the trial court found that there was no 2307 public policy that was jeopardized by the dismissal of the plaintiff in this case. And there's the case law in the Zoc case, which found that there was a public policy, a clear public policy in keeping non-conforming airline parts out of the stream of commerce as well. With respect to Zoc, the trial court attempted to distinguish that case on 2 grounds: that Keehan didn't have the ultimate authority to ship or withhold those parts, and that the plaintiff wasn't dismissed because he refused to violate the statute. That's not Really, the elements of a common law Greeley case, there just has to be that public policy found in statute, and then an action by the employer that would jeopardize that public policy. And the complaint states both of those elements with enough particularity to satisfy notice pleading. Finally, the trial court found that Keehan the plaintiff only pled a 41-1352 derivative claim. And it's true in this case that the plaintiff did plead a 41-1352 derivative claim. However, that's not the only public policy that was alleged in the complaint. As I previously stated, there were 4 other statutes within the complaint establishing that clear public policy, so that the elements of 41-1352 do not have to be met. If it was only the public policy contained in 41-1352, certainly the plaintiff would have to plead all of the elements of the whistleblower offense. With respect to the whistleblower claim for relief, the plaintiff's position is further that the complaint sufficiently pled a whistleblower claim under 41-1352, sufficient to satisfy notice pleading as well. The elements are rather simpler for a whistleblower claim. It's that the plaintiff was engaged in activity protected by statutes, that the employee was subject to an adverse employment action, that there was a causal link between the plaintiff's activity and the adverse employment action. The question here is whether the plaintiff was engaged in an activity prohibited by statute or protected by statute, and the complaint sufficiently places a number of allegations. First, the plaintiff has to become aware of a violation of law. Again, the plaintiff alleged violations of the non-conforming airline parts entering the stream of commerce, not reporting W-2s correctly for employees, hiring individuals who were not qualified to work in the United States, and then not assessing proper sales tax. All of those the plaintiff became aware of and was reasonably sure that those were felonies or harmful to the public, and he orally notified a number of supervisors. And the complaint admittedly doesn't step by step go through who was notified first, oral, written, but there's allegations in the complaint that oral notice was given to at least 6 specific individuals. The next step in a protected activity is that the employee has to follow up with a written notice. Again, the trial court found that written notice was only given to the Vice President North America of Morgan Advanced. That's not what's in the complaint, Your Honors. The complaint specifically states 4 individuals who received written notice. Kudzall, Villeman, and of course Mr. Stang, and then Ms. Polton as well. For whatever reason, the trial court's decision states that only Mr. Stang was given written notice. And that's just not what's contained in the complaint. Finally, after written notification, a plaintiff has 24 hours to report those violations of law to an outside regulatory agency, police, FBI, what have you. In this case, the plaintiff opted not to do that. The trial court found that because he did not do that he was not subject to the protection of a whistleblower statute. Again, and this is written much more eloquently in the brief, the requirement of oral and written notification states that the plaintiff shall make written and oral notification to a supervisor, but that with respect to going to an outside agency, the word is may. The plaintiff may go to a regulatory agency. So it's not required that a plaintiff go to an outside regulatory agency, but it is permissive. There was some conversation about individual liability as well. Obviously, we do not have another case to rebut the Armstrong case from Coshocton County from the 5th Appellate District, as the 5th Appellate District stated that it's an issue of that they had never seen in any other Ohio courts. However, our position is that a plain reading of the statute says that an employer includes an employer's agent, not business entity agent, not corporate entity agent, just an agent. So a plain reading of that statute would suggest that individual liability may attach under the whistleblower statutes. Finally, the trial court did make mention on a number of occasions that it was not going to entertain any paragraph that was deemed a conclusion of law. And the one instance off the top of my head I can think of was that the plaintiff's complaint stated that supervisors were properly noticed with respect to the 4113 notice requirements. Obviously, a trial court does not have to entertain bald assertions of law, and the plaintiff, of course, concedes that. However, this is a 155 paragraph complaint. It's not as though the complaint just states, assertion of law, assertion of law. There are facts contained with that assertion of law, and in the instance I gave you, plaintiff properly notified supervisors. If you take out the word properly, you have an assertion of fact, plaintiff notified supervisors. So to say that you're not going to entertain assertions of law is certainly allowable under the civil rules and under pleadings, but it's almost disingenuous. It's not an assertion of law on its face. It's a required element to be pled for a whistleblower statute, and there's really no other way to do it. So for all of those reasons, we would ask this court to reverse the grant of the 12b6 motion to dismiss and remand this case back to be heard on the merits. Thank you.
May it please the court, my name is Rebecca Bennett, and I'm counsel for the defendant appellees, the Certech defendants. Certech defendants ask that this court affirm the lower court's motion to dismissal entry for 4 reasons. First, Mr. Keehan failed to strictly comply with the requirements of the whistleblower claim when he did not provide oral notification and a written report with sufficient detail to the same person. Second, Mr. Keehan's public policy claims fail because they are by and large derivative of the whistleblower claim. Although he claims that policies were violated, what he's really saying is that I got terminated because I reported violations of policy. And there is case law in this district and throughout the courts in Ohio that affirm that those types of claims have to be pled as whistleblower claims. You can have a derivative whistleblower claim that's a public policy claim, but you still have to comply with the strict requirements of the whistleblower statute. So Mr. Keehan's claim would still fail in that regard. And to the extent that any of those public policy claims pled are deemed not to be derivative of a whistleblower claim, those claims still fail under the clarity and the jeopardy elements. First, those claims fail under the DOHME standard, D-O-H-M-E 2011 Ohio Supreme Court decision that talks about needing precision in identifying the specific policies that underlie your claim. Interestingly, the DOHME case was decided after the Zach case that plaintiff relies upon in this case. The Zach case, Z-A-J-C, I'm just assuming it's pronounced Zach. The Zach case was an 8th district case back in 2007. And finally, Mr. Keehan cannot meet the jeopardy elements of his public policy claim. I want to talk a little bit about the public policy claim first because that's the claim that counsel talked about in her argument. One of the things that's important here is that 2 of the broad public policies that Mr. Keehan asserts are tax code violations. And so this court, in a case called Erda v. Buckingham Doolittle, back in 2006, already addressed this issue and said, when you assert the tax code as the basis for your wrongful discharge and public policy claim, that you're really asserting a derivative whistleblower claim. So then you still have to go back and meet the whistleblower elements. So certainly the tax code claims fail on that basis alone. Next, there's an immigration type claim. The statute, the source of the public policy is 8 U.S.C. 1324. In fact, that's the only specific section that Mr. Keehan cites. In the rest of his public policy claims, he cites entire chapters of the law. For instance, he cites Chapter 57 and Title 26. But so the immigration issue prohibits unauthorized persons to work in the U.S. But when you read the actual factual allegations, Mr. Keehan is talking about individuals from Puerto Rico. They are authorized to work in the US. So even if what he's claiming is taken exactly as true, there's no jeopardy because that law has not been jeopardized in connection with his termination. So what that leaves then is the claim regarding non-conforming airline parts. There's a commercial code cited. It's the whole chapter. Chapter 2307 is cited in the complaint. Well, that still doesn't help Mr. Keehan. First of all, Certech doesn't sell airline parts. Certech does not produce any single part that goes into an airplane. What Certech does is creates ceramic cores that are used by other companies who metal form, and they use the cores as part of their molds. So nothing that is produced in a Certech plant ever goes to an airline. So this statute cannot be jeopardized by Mr. Keehan's conduct in connection with any of the parts that are produced.
Counsel, just hearing you argue, though, it sounds like you're arguing something.
Well, but see, that's the point, is that in this case, he has to plead. He would have to plead that Certech makes airline parts. I read the complaint through and through. That's not pled anywhere. It's not pled in the complaint. That's his obligation to make that factual allegation. But even if you say, okay, we'll prove that, wait, take your depositions, do your discovery, prove that in court, it's still a whistleblower claim that he's reporting. He's not, in the Zach case, you had an individual who was responsible for inspecting goods, who was terminated for refusing to ship defective parts. Well, that's not Mr. Keehan's job. He's not involved with shipping parts. What he's saying is, I complained about it, and then I got terminated. I complained about it, and that's how the complaint reads. And if in fact that's true, then that's a derivative whistleblower claim. So if you compare the public policy claims that Mr. Keehan cites in his brief to support this, they all have to do with employees refusing to take an action that would violate the particular public policy. Well, that didn't happen here. In fact, in this case, it's a third party, this flexible staffing company, that's the party engaging in all this unethical conduct or potential wrongdoing. It's flexible staffing that's allegedly violated the tax code. It's flexible staffing that's allegedly taken these actions with regard to immigrants, etc. So the Certech defendants do not have any control over what flexible staffing does or doesn't do. And more importantly, it was, as the site manager, Mr. Keehan's job to manage the temporary agency, flexible staffing. And he did. When he brought this, and this is all in the complaint, when he brought this to the attention of Certech, Certech said, well, why don't you discontinue the services of flexible staffing? And Mr. Keehan did. And so the problem was addressed because Mr. Keehan was the individual who had the authority to correct all of those problems. With respect to the whistleblower claim, so the whistleblower claim, the 4113.52 claim, Mr. Keehan did not make an oral report and a written report to the same supervisor. And that's actually a strict requirement under the whistleblower statute. And as this court undoubtedly knows, that the whistleblower statute requires strict compliance. So if you do things in the wrong order, if you miss one single step, then you haven't properly pled the claim. Now, in Mr. Keehan's case, he makes very specific statements in the fact section of the complaint about who he talked to and who he issued a letter to. And none of those people, the individual he issued the letter to was Mr. Stang. He never made an oral complaint to Mr. Stang. He never issued letters to the people after making the complaint that he made verbal complaints to. And so later in the complaint, in the law section, where you repeat the prior and incorporate the prior allegations, and then you give a few lines about the elements of the claim, that's where Mr. Keehan says, and I also made written reports to others. But that's not enough to plead and to meet the pleading standard. And the reason is because the whistleblower statute says you have to allege a written report that provides sufficient detail to identify and describe the violation. So it's not enough to simply say in the complaint, I made a written report. You have to show that you made a written report that provides sufficient detail to identify and describe the violation. And he didn't do that anywhere in the complaint. The reality is, there was only one written complaint. And interestingly enough, when you look at that written complaint, which we attached to the motion to dismiss below because it's referenced in the complaint, when you look at that letter isn't a whistleblower report. That letter was a report that Mr. Keehan's attorney sent because Mr. Keehan was afraid that he was going to be held responsible for this flexible staffing's activities. And so the purpose of the report was to go through all of the things he did to remedy what Flexible did. Well, that's not a whistleblower report. A whistleblower report would be a report that says, here are the things going on that need to be fixed. That's what a whistleblower is. A whistleblower isn't somebody who's responsible for those things and who says, here are the things that I've done to fix the problems at the company. In addition, Mr. Keehan did not report orally or in writing this alleged activity to his employer. As you'll notice in the complaint, there's all sorts of other entities. There's Certech, his employer, and there's entities that are related to a company by the name of Morgan. So Morgan has an ownership interest in Certech, but Morgan is not Mr. Keehan's employer. The individuals that he mentions by name that he made complaints to all work for one or another of these Morgan entities. So if he wanted to meet the whistleblower requirements, he would have had to complain to the officials at Certech, not to the officials outside of Certech. In addition, as I mentioned before, with regard to the public policy claim, Certech did not have the authority to correct any of these violations. That is also important in connection with the whistleblower claim, because if you read the elements, that's the very first element. It has to be something that the employer has the authority to correct. And that's another reason why he cannot sustain his whistleblower claim. And for these reasons, defendants request that the court affirm the lower court's decision to dismiss the plaintiff's complaint.
Thank you, Counsel.
Your Honor's inclination at this point is correct, that this feels and sounds as a motion for summary judgment. And even listening to the difference between my argument and opposing counsel's, you can see the importance of the notice pleading. The defense counsel has access to so many more facts regarding the defendants and different, the corporate entities and all of that than we do, because we just don't have access to this information. Defense counsel pointed out that the staying letter was the only letter in the complaint that was kind of fleshed out with a lot of particularity. Your Honor, that's because that's the only letter we have. That's the only letter we have access to. All the other information necessary to prove our complaint is in the custody of the defendants. We have the staying letter because we drafted the staying letter. And that's the importance of this notice pleading, is that we put out facts, allegations that we believe to be true that become substantiated through the discovery process. Again, I would like to point to the federal court order that states that 2307 is in fact a public policy that can be used for a Greeley claim in common law. The federal court found that way, and the Zock case also found that way. The difference between Mr. Keehan and Mr. Zock in those two cases the argument seems to be that the status and the final say ability of Keehan versus Mr. Zock is the differential, what distinguishes Keehan from the Zock case. Your Honors, that's not a distinction that should be made, first of all, because it draws a distinction between somebody who would be examining airline parts or any non-conforming part, say on a floor as they pass by on a conveyor belt. As somebody, the Greeley protections should not only vest in someone a higher up who has the ability to say, no, we're not shipping these parts, but to anybody who could prevent non-conforming parts from entering into the stream of commerce. That's good policy. That is protecting jeopardy to a good public policy found in 2307 of the revised code. Again, we would point out that the whistleblower claim for relief does not require that the employer's actions are the ones that constitute a violation of law or a felony. Instead, it's an action that the employer has the ability and authority to correct. And in this case, it's clear that the defendants had an ability to correct the third-party flexible staffing's actions and malfeasances, either through management or through the individual workers, because as defense counsel stated, flexible staffing ceased to staff the corporate defendants. So it's not necessarily the action that the employer is engaged in personally, just actions that the employer has the authority to correct. And again, all of this is in the complaint. We'd just like to reiterate that notice pleading here has been met again, we submitted a 155 paragraph complaint, and that the trial court was able to render a 20-page opinion on, or order on, dismissing that complaint. Dismissing, might I add, with prejudice, instead of looking at the complaint and saying, there's a lot here, why don't we give you leave to file an amended complaint to make this clear, or let's dismiss without prejudice. Basically, the outcome of this case was that Mr. Keehan was denied protection under the whistleblower statute, under the wrongful termination common law claim for relief, and then denied relief in court as well, because his complaint was just dismissed outright without the ability to refile or amend. Thank you.
Okay. The court will take the matter under advisement, and a written opinion will issue and be sent to both sides. We also release on our website and the Supreme Court website